People versus Ashley Burgess.
I'm Sandwich Tom, 6296. Appearing on behalf of Ms. Burgess, consider your name.
Ashley Burgess.
Good morning to Mr. Didal. What do you got?
Right, please step for a bond violation hearing slash. We have offer that my client would like to avail herself to, whereby there will no longer be a bond violation. My client will be filling an amended charge, disorderly conduct.
Right.
771 for a period of 3 months.
Okay. Do we care which charge we dismiss and which charge we reduce? All right, Ms. Burgess, did you discuss your rights and options with your attorney?
Yes.
You understand all those rights and the options they give you? Do you understand the possible penalty for the added charge? Understanding the added charge and your rights and options, are you pleading guilty to the charge freely and voluntarily today? Mr. Jadal, I've got an incident date of October 23, 25. Could you voir dire?
Leading back to October 2025, within the township of Huron. At that time, did you make persistent phone calls to father of your unborn child?
Yes.
And that was you agreed that you did with the intent to arrest. Is that correct? I'm satisfied.
So am I. I'll accept the plea to the added charge, dismiss both the original charges. What should I know about the lady before I sentence today?
She is present, very emotional time of a relationship, pregnancy. There was another woman at the scene that she is currently, Your Honor, getting mental health.
Good. We're at.
Well, I know the name of my therapist's name is Amy. I don't know the name of the.
Okay. How often you going? Good. How long you been going?
Anything going on.
Okay. When's baby due? Oh, congrats. Good luck. Yeah. All right, go ahead. I'm sorry, counsel.
By that at the last thing we provide proof of her mental to the prosecution and support this deal. She's going to do everything that she can to still for the next 3 months. She doesn't need this on a record, doesn't want it on a record. She understands to continue the no contact issue. She will do that.
All right. Are you working?
Maternity acquaintance.
Where were you working at? Okay. How long were you there? Okay. Anything you want to tell me? Don't feel that you have to. Okay. And I'm assuming no criminal history. All right, Ms. Burgess, I will delay sentence for 3 months. During that time period, stay out of trouble, no new criminal charges. I'm assessing court costs the amount of $500. Can you pay that today or can you set up a payment plan today? And I think there's also a no contact with victims.
You understand? She's not like that.
All right. Just so we're clear, no contact, like no social media, no phone calls, no letters, no Hallmark cards. You see them at Taco Bell, you're eating at Burger King. You don't tell your friends to go see how they're doing, just no contact. All right. Okay, good luck to you. Go downstairs and set up something on payments.
What we witnessed in this hearing was not just a routine probation violation proceeding, it was a powerful moment that shows how fragile freedom can be when someone is already under court supervision. The defendant was originally on probation for possession of methamphetamine, a serious felony offense. Probation is not simply a lighter punishment, it is a structured opportunity. It is the court saying, we are giving you a chance to prove you can live within the law. That opportunity comes with strict conditions, no new crimes, no substance use, compliance with reporting rules, and respect for the law. In this case, the allegations were significant. The court outlined non-technical violations, including driving without a valid license, driving without insurance, driving with an invalid plate, and operating a vehicle with an open container of alcohol. On top of that, there were technical violations, alleged alcohol use, possession of paraphernalia, and failure to report police contact within 24 hours. When someone is already on probation for a drug felony, These types of allegations raise serious red flags. What stands out most is the tension between accountability and due process. The judge clearly separated two issues: whether the violations occurred, what consequences should follow if they did. That distinction matters. Even though the defendant had pled guilty in another court to related charges, he still had the right to contest the probation violation in this courtroom. The burden would be on the prosecutor to prove it by a preponderance of the evidence. That is an important legal safeguard. However, the defendant's decision to dismiss his court-appointed attorney introduces another layer of risk. Representing oneself in a probation violation hearing is rarely wise. The judge carefully explained the dangers, not understanding evidentiary standards, not knowing how to question witnesses, and not knowing how to present a defense. The law is technical, and probation hearings, while less formal than trials, still require strategic legal knowledge. Then came the defining moment of the hearing, the drug test condition. The judge granted an adjournment, bond was continued. But that continuation was not unconditional. The defendant was ordered to immediately submit to a drug test. The consequences were crystal clear. If he tests negative, he remains free until the next hearing date. If he tests positive for any controlled substance, his bond will be revoked and he will go directly to jail pending the hearing. This is what makes the moment so dramatic and so real. His immediate future hinges not on argument, not on persuasion, not on courtroom theatrics, but on one biological fact. A drug screen becomes the dividing line between freedom and incarceration. In probation cases, credibility is everything. Judges look for patterns, compliance, effort, honesty, stability. A clean drug test can signal progress and responsibility. A positive test, especially in a case rooted in drug-related conduct, signals regression and heightened risk. The hearing also reveals something broader about the justice system. Probation is both opportunity and surveillance. It is a second chance, but it is a monitored second chance. The system provides freedom, but that freedom is conditional. When someone on probation accumulates new charges, even if relatively minor traffic-related offenses, it can suggest a pattern of disregard for legal boundaries. Ultimately, this case is not decided yet. It is paused, suspended between two possible outcomes. The adjournment gives the defendant time to hire counsel and prepare, but the drug test requirement ensures that the court maintains control over the situation. In many ways, this hearing serves as a reminder: when you are on probation for a serious felony, every decision matters. Every traffic stop, every interaction with law enforcement, every substance choice carries amplified consequences. One test, one result, one decision away from jail or another chance to stay free. That is the reality of probation.